Adjournment request, if any, from item number 1 to 6. From item number 7 to 13.
Lordship, with the concern on the other side, I'd like to mention item 13, Lordship.
1-3.
1-3, my lord.
You are for,
Lordship for the response.
have you informed the other side?
Lordship, I'm for the appellant, my lord.
As prayed for on behalf of the respondent and agreed to by the counsel for the appellant. The matter is adjourned to sometimes in July,
My lord, may kindly fix it in the second week of June. Possible.
second week of June.
Grateful. Deeply open.
12 June.
It's about that building which is
Which
occupied by CRPF.
Yes,
Is that correct?
yes, sir.
Have they vacated or they are still there?
They are still there, my lord.
And
My
who
lord,
is paying the electricity cost?
my lord, we are bearing the electricity cost, my lord.
On your own?
Yes, my lord.
I mean, we'll see.
Would like.
From item number 14 to 22.
May please, your lordship.
Yes.
Lordship, in item number 16, we have filed an IA, my lordship.
16, you have filed an IA.
My lords, in the IA, there is an additional affidavit which needs to be on record.
But 16 is analogous with 15.
My lord, there is an additional affidavit we have filed on day before yesterday, my lord. If that may be called on record.
Oh, that we will not do. That we will not do. It will come later. Next week, we keep all this. These are artificial flash floods and all.
My lord,
The same issue.
my lord.
This is area is different. This is only number.
Area is different.
No.
I think we will hear it together.
Wait, please. Wait, please. Item number 18, my lord.
Just a minute. We have not passed any order on 15 and 16. Again, let these two PILs be listed on so and so date in June.
My lord, the matters will be taken up today, my lord. There is an urgency.
You said no.
My lord, I only called for the additional affidavit if that may be.
Tomorrow.
My lord,
Lordship, there is an interim order, Lordship.
For tomorrow, you are apprehensive. Nothing is going to happen. No? The government- Tomorrow. What is it?
Interim order, Lordship, the next day is there.
Are you afraid that without the interim order, anything will happen in a day? We are asking,
tomorrow.
we are considering it tomorrow. So let it remain day after tomorrow.
my lord, tomorrow would be.
Day after tomorrow, interim order in the meanwhile shall continue, if any.
Deeply obliged.
Lordship, day after tomorrow, Lordship, my senior has some difficulty.
The next Monday, it goes on Monday. Monday is the date,
Yes,
15th.
My lord, Monday would be.
Lordship, I apologize. Lordship, my senior Mr. Kane Sadri is appearing in the IA, your lordship. He may not be available on Monday, your lordship.
Then,
Lordship,
when would he be available? Tuesday?
tomorrow, I was on
Tomorrow we will not do it.
Lordship, Tuesday or Wednesday.
Next Tuesday.
Much
12 5.
Wait, please, Your Lordship. Item number 18, my lord, we have received some RTI, my lord, information. So we want to bring them in a record, my lord, by way of an affidavit.
This is about Tiba
You are
Autonomous.
not counsel, my lord.
As prayed for on behalf of the petitioner, re-notify. So and so date.
And your best.
20th July 20.
May please, Lordship. Lordship, item 22. Due to some-
German slip has been circulated. All right.
Lordship, take this matter after 3. After 2.
24th July.
Obli-
From item number 23 to 31.
With the consent of the respondents, I beg to mention item number 26, which circulated in adjournment slip minutes. We're filing an additional affidavit in this matter.
All right. Yes. Take the date now.
Yes,
14th July.
grateful.
Wait, please, Lordship. Lordship, with the concern of the other side, I beg to mention item number 29, Lordship. Lordship, we have not circulated additional slip, but Lordship, we have taken consent from the other side, Lordship. I prepare for an adjournment, Lordship.
As prayed for on behalf of the appellant state. Let this matter come up for consideration on your date. set.
15 March. 15 May, my lord.
July.
July.
27 July. 20. 20.
Yes.
Any other request?
33. No, 33, my lord. In this case, initial when this motion is issued here. But here, my lord, I pray for implementing Mizoram government as a party respondent, madam. And so,
Notice is served upon respondent 1, 2, 3.
Yes,
as per
ma'am.
track report.
Yes,
Now, what do
yes.
you want?
and another my prayer was that on that, madam, the Mizoram government, I will pray for implement, madam.
Have you filed any
No,
IA?
madam, actually, petitioner sent through postal service, madam. I have not received yet, madam. So, my lord, this, I may be allowed some time, madam.
As prayed for on behalf of the Union of India and others, Mr. S.K. Medi, learned CGC, seeks some time to put in additional affidavit.
Well, implementing petitioner.
To put in an affidavit seeking implement of the state of Mizoram. List this matter on after 2 weeks,
3 weeks, my lord.
after 3 weeks. Why can't you make your prayer simple? I don't know what all you spoke, and ultimately it turned out to be an adjournment. Like you should say something which is intelligible to the bench.
Yes.
I couldn't
Yes.
find even a word of what.
Sorry.
Not sorry, but I was just wondering, what do you want?
Yes, my
You
lord.
want an adjournment? You could have done it even today. We would have permitted you to make the necessary change with permission to you to take of filing a corrected memo of parties later. But anyway, you do whatever you wish.
22-6.
Fine.
Daily list for orders item 1.
Your Lordship, this is an appeal filed by the state of Assam challenging the OM dated first
Well,
of
here's for respond number 1.
Lordship, we have taken dusty service.
Giving one more opportunity.
Lordship.
Giving one more opportunity to respond number 1 to contest this petition. The matter is adjourned to after 3 weeks.
24-6. Item 2.
Respondent sharing, respondent 6 and 7. What is for please to notice.
May you please, Your Lordship. Lordship, in this matter, the respondents has filed and
Let notices also be issued to the newly added.
Yeah, my lord,
You are appearing for respond number 6 and 7.
Yes, my lord, that's where my little observation, praying before lordship, because, due to, this pretty appeal,
All right.
there is no stay order, but this land which is portion of land is not
How much
handed
are
over to us. That is why entire, our construction will be held up.
No, that we understand. Now you have appeared.
So therefore, this matter is to be listed for admission.
Admission.
That we are going to do immediately.
Yes, sir, shortly, because,
Same
yes,
thing, I would repeat what I said to Mr. Medi.
and that's why, but whatever.
Again, Mr. So-and-so, learned counsel has appeared on behalf of his newly added response number 6 and 7. Stop. This way, the service on all the respondents is complete. Let this matter come up for consideration in the, under the appropriate heading of admission on your date next week.
obvious.
Correct?
Yes.
What is the use of saying all this?
That's her side, because.
Anyway,
19-5. Item 3.
Service upon respondent number 7.
Actually, that's it.
you are appearing for respondent number 7 in this, Mr. Barua.
Yeah.
In this matter also.
No.
Well, take your seat, sit down.
I did not.
Taken steps for
He has taken.
Notice.
Have you taken steps?
Yes, ma'am.
Issues of notice.
Yes, Lord.
R7.
For 7.
Awaiting
Service
the
report.
report regarding. Awaiting the report regarding service of notice on respondent number 7. The matter is adjourned to 2 weeks.
Much up.
26-6. Item 4.
since delay of only 14 days.
14 days, my
We
lord.
would have otherwise condoned. But yeah, you're here.
Yes, I'm for the PhD department also.
No, for respondent number 11.
Last focus on lawsuit observed considered.
Has he been served?
Other two persons.
There is no report.
No report lawsuits, but
Awaiting
other
the
two
report
persons.
regarding service of notice on respondent number 11 and his appearance to contest this IA preferred by the applicant seeking condonation of delay of 14 days in preferring the connected writ appeal. Let this case come up for consideration on after 2 weeks.
Bye-bye. 76. Item 5.
Respondent number 11, concern, but respondent number 15, insufficient address. Return.
Respondent number
15.
15 insufficient reference.
And respondent number 13, no such person. Raise that.
तो 13 को delete कराते हैं 11 को delete कराते हैं 15 में fresh notice कराते हैं
13, no such person, but you can.
But 13 and 15, my lord. Notice has been
13
issued.
also perhaps the address is incorrect.
Yes, my lord.
11 has expired.
Yes, my
So
lord.
file an application for deletion of his name
Yes, my
in
lord.
the same affidavit.
Yes, my lord.
One affidavit you have to file for deletion of his name
Yes, my
on
lord.
the ground that he has
Expired.
expired.
Yes, my lord.
And then 15 and 13 fresh notices.
Yes, my lord.
Again. Except for response number 11, 13 and 15. All other respondents are reported to have been served. It has been submitted to the bar that respondent number 11 has died. Ms. Gayer, learned CGC, submits that by the next date, necessary application shall be filed for deleting the name of respondent number 11 from the array of parties. She shall also take fresh steps for issuance of notice on respondent number 13 by both modes. After providing correct and present address of the aforenoted respondents, returnable 6 weeks.
Must be blessed.
27.
Within 2 weeks. Requisites within 2 weeks, returnable 6 weeks.
Must be blessed.
27 July. Item 6.
Which report have it there? No, which looks to.
So the report on 1 and 2. Awaiting the report regarding service of notice on response number 1 and 2, the matters that you are doing.
Second July. Item 7.
My lord, the state has prepared this appeal, but the delay of chairman's meeting, they will find
What
out.
is the ground for condonation?
Yes,
You are not given any ground.
Lordship, our grounds is lordship, we sought for, some time was taken because we sought for leave.
no, they say only that after finding.
Just a minute, she has not completed.
I apologize.
But lordship, in this matter, I'm led by Mr. P. Naganesh Meji, lordship. He is in another court. Lordship may pass over the matter for the time being, my lord.
All right. Next date. Next date. But then you
Lordship,
have
we'll
not
be
said
here
it.
in some time, lordship.
These grounds do not appeal to us. Next date, why do you want, you have been able to avert the order of dismissal now, so take it next week. As paid for on behalf of the appellant applicant, let this matter come up for consideration on your day. Ask your senior to be here.
Lordship, on Monday.
Monday.
11.
13.
Or in the meantime, you can file a fresh affidavit. We don't mind. You have not taken any good ground. Anyway, yes. Next week.
Deeply obliged.
Item 8.
Do respond number?
Sole respondent.
Awaiting the report regarding service or notice on respondent, on this one responding, the matter is at 3 weeks.
26-6. Item 9.
Hello, item 9, 10, 12, and 34, my lord. All these petition relates to my lord, the petitioners are seeking benefit of old pension scheme. This series of cases are fixed on 12.
Separate kar dena. But then notices have to go, no?
They are on other cases are allowed to be condoned the bill.
Those cases where you have withdrew and come back again.
Yes,
Ah.
but here, my lord,
Notice except notice.
here, my lord, justice.
In all these matters separately लिखना. Look at me, no? How do I know that you're 9, 10 and 12 में
And 34.
There's an application seeking condemnation delay. Notice to so and so. Notice to respondents. Notice is accepted by Mr. Pujari. Let this matter come up for consideration on
12, it is fixed for hearing, my lord.
No, we can condone the children. Already we have condoned.
Yes, your lordship has condoned. One,
I think we have annexed it in 34.
yes, one is there, I can show.
will not rush. Will not simulate. Way. You want to respond?
It can be fixed on 12, minor keeping the issue of minor condemnation open, minor. Because some matters are fixed on minor 12.
Series of matters are fixed.
Yes. For admission hearing, minor.
Delay condone. Let all these matters be listed along with source.
And that is
Take order from.
well, yes,
Retaping
minor,
three,
the
25.
leading case is minor, retaping it's 258 of 2025.
You said, thus when have you annexed that earlier order? Which petition? 34.
Earlier order is there here also, my lord, at page 299.
Well,
Two orders are there. One is from single judge, similar orders.
Check.
Single judge order is 341.
Yeah, I don't remember.
Okay.
Okay, okay.
This person came into the government, they are considered.
So, like,
Item 11,
Delay of 535 days. yeah.
Notice.
You can accept.
Accept notice. Lordship. So and so application, Mr. So and so accepts notice. Would you like to file an affidavit? Lordship, please. Mr. Das takes time to respond to the aforementioned application. For the aforesaid purpose, he seeks some time. Let this matter come up for consideration on after 3 weeks.
much obliged.
76.
Blessed.
Supplementary list item 34.
No, 34 is along with this.
Okay.
9, 10.
Okay. Daily list for admission item 14.
Yes.
For the private respondents, appeal by the forest department, lordship. The writ petition also, they remain absent at the time of consideration.
Nobody appears on behalf of the appellant. The counsel for the respondents are present. Let this matter come for consideration. Give a date in July.
May I pray for a
29
short date, lordship? May I pray for a short date? lordship?
You have to take a call. Otherwise, there is a direction for vacating the premises. You can't make it without acquiring it.
Lordship.
Or you pay the money, you enter into some kind of
No,
settlement.
lordship, that is for the forest department. We are the landowners, lordship.
Also, there you are the landowner. no?
Yes.
Yes.
We were
We'll give
directed.
you a short date,
Lordship.
but doesn't matter. You have to have them vacated. What date did you give? June.
17 June.
Blessed.
Item 17.
Joy in public school.
11-3 order.
Mr. Khatniar was supposed to respond.
My lord, not received any affidavit yet, my lord.
This is that Join public school
Yes,
which has
my
been
lord.
taken over by
The
the
university,
university.
my lord.
Is that correct?
That is correct. That is the case, my lord. Our property has been occupied, my lord.
Your property,
Not my
It's what?
property.
the
Property,
property was given to you. It's not your.
my lord, the property for the
Anyway.
down to road.
Yeah, for the absence of Mr. Khatniar and Standing Council, Department of School Education were to respond to the petition. The matter is adjourned to after 2 weeks. Eight,
Obla-
take care of number.
Oblige.
17 June.
Much क्या हो गया आज तो election उसमें सब हो।
Remember display here, I don't know.
Display board है।
Yes. Item 19.
Yes, who appears for the other side? Who appears for the other side?
The government, my lord.
हाँ, बताइए। Nothing, the 11th single judge has not taken into account that this lady was married. There was discontinuance of education. I mean, that condition could not have been taken into account for setting aside that appointment. We'll have to stay, but then has somebody else been appointed? Mr. Biswas?
No. They are processing for new advertisement.
Right. You don't have to say anything. Again, we have heard Mr. S.C. Viswas, learned advocate for the appellant. This case concerns the appointment of the appellant as an Anganwadi helper and the subsequent challenge to her eligibility on the ground of her being a student, her being a regular student at the time of her selection. Against an advertisement, next paragraph. Against an advertisement dated 31/3/2022, issued by the competent authority, inviting applications for Anganwadi helper posts with the eligibility condition that regular students of school or college would not be considered for the post. The appellant had applied and had returned successful. And was returned successful. She was selected and appointed on 19/7/2022. And thereafter, and ever since thereafter, she had been discharging her duties. Instead of later, her appointment was challenged by respondent number 5, alleging that she was ineligible as at the time of her appointment, she was a regular student of BA in BP Shalia College, Nagar Bera. Though the appellant had contended before the learned single judge that she was a student in the aforesaid college, but on account of her marriage, sometimes in the year 2022, she had abandoned her studies after appearing in only the first semester of the course. Thus, at the time of her appointment, she was not a regular student.
Exactly.
In support of the aforenoted contentions, in support of the aforenoted contention, Mr. Biswas, learned advocate for the appellant, has submitted that it was pointed out before the learned single judge that there was a marriage certificate of 26/2/2022 on record, and and perhaps another another certificate, perhaps of the appellant being a college dropout from 11/10/2022. Those assertions of the appellant were never specifically contested by respondent number 5. The grievance of the appellant today in this appeal is that the learned single judge, by the judgment impugned, allowed the writ petition preferred by respondent number 5, and her appointment was set aside, holding that she had been a regular student at the relevant time, which finding was primarily based on a college certificate indicating that she had been a student of the aforementioned college. The sum and substance of the argument of Mr. Biswas is that these facts have been completely ignored by the learned single judge. Let response affidavit on behalf of the state as also respondent number 5. Have you issued notice? Let notice be issued to respondent number 5. As a legal, notice to respondents number 1 to 4 is accepted by
Yes, my God, government, my God, one M Kalita.
अपना नाम बताइए.
M Kalita, my God. M Kalita.
Mr. So and so. Let notice be issued to respondent number 5 on steps being taken by the appellant within a period of 1 week, both modes returnable, sometimes in July. So in the meantime, the judgment impugned shall remain under abeyance.
24/7.
There you go.
Item 20.
May it please, your lordship.
Yes.
My lord, appellant before your lordships,
Yes.
their erosion affected land, let's speaking.
Yes.
And my lord, if I take your lordships to page 100 and 102, your lordship will find that the allotment was issued way back in 1971. At page 100 first, my lord.
Now, Mr. Datta, two things. Now, under 145 also you succeeded. Therefore, you're not being disturbed.
My lord.
All that you wanted was that there should be a permanent grant of patta to you.
Exactly.
The single judge says that unless the VGR is de-reserved, that can't be done. Has the single judge gone wrong?
My lord, that way, my lord, if I take your lordships at page
Just to answer this, Mr. Datta,
Right.
we'll get back. We will ask for the response of the state, but prima facie, the motion stays only. I mean, can it not be disposed of? Well, let it be done.
Yes, yes.
And we can't give a direction to the state to de-reserve a VGR.
My lord,
Notwithstanding the fact that you are residing there, they'll have to make some other arrangements. But VGR is as important as providing accommodation to people who are staying there.
very right.
There
Very
can be
right.
no two disputes about it.
Yes. But then sanction for de-reservation is already there.
And in fact, you should not have stoked this fire. This is stoking a hornet's nest, in these times.
I understand.
In these times, Mr. Datta, your clients have stoked a hornet's nest. Now, if the state comes up with a plea that this is very essential, and then they proceed ahead, but they are not disturbing you.
Yes.
If they are not disturbing you, why do you want that kind of permanence? For your benefit, I would only request you to take instructions from your client whether to pursue this appeal. Let it remain under wraps if at all you want to stay there. Because my understanding of the situation is, after remaining here for about 9.5 months, approximately 10 months, the moment you make this obvious that your settlement is on a VGR, the other side would get active.
I could get the message across.
So what we do is this. We are not asking you to withdraw. We are not asking you to concede. We have our position is circumscribed by our self-imposed limitations under Article 226 of the Constitution. This is only a continuation of it.
Well,
Don't let the state take this opportunity of displacing you and putting in others later. Why to do it?
that's a very,
You should be happy with 145 declaration that you're in possession. That's all.
in fact, my lord, I was thinking in that manner, but then the client went to the 226 jurisdiction.
We can issue notice. But that would be penny wise, pound foolish.
My lord, let me get the instruction.
Take the instruction and don't press this. As long as it is not harming you. The moment you are being dispossessed, come. See, you know our bounds.
Yes,
And especially this court will never cross a Lakshman Rekha.
I understand.
Unless it's a matter of personal liberty. So here they are allowing you, they are not disturbing you, they have not issued any notice to you. And you want a patta immediately. You want a direction from us for this reservation of VGI. I don't think this court. अब वो तो आपको ये कहने के लिए for allowing your writ petition, for setting aside the order passed by the learned single judge, we will have to record that because of the past experience and their expectation and a decision taken by the government of de-reserving it, let it be de-reserved. Can we do that?
My lord, that way, lord.
That is a political decision which cannot be, that cannot be a ground for passing our orders under Article 226. That's our limitation. Why stoke it?
But my lord,
Take instructions.
without going into any nitty-gritty of the thing, lord, can I just for a while take to your lordship at page 102? My lord?
Yes.
Is they're talking about de-reservation. Now, with reference to above, I am directed to convey the sanction of the governor of Assam to de-reservation of land measuring so and so, so and so. That means sanction was there in regard to de.
That's true. Had it been my state, now there would have been 5 public interest litigants, courtbirds, interlopers who would have said that look at this decision of the government, and they would have become intervener applicants. I have seen such rough weather, no? But many a times as a lawyer, I have to retrace my steps that if nothing is happening, let it remain. That's the thumb rule.
Yes,
If
and the
you're not
land
being-
policy also very stringent.
If you're not, see, as a matter of policy, this is bad. So as a thumb rule, unless you are being driven out, hold back. Now take a call.
My lord, I'll take some instruction from my client.
As prayed for by Mr. S. Rafael and senior advocate for the appellants. The matter is adjourned to take your time and come back to us in July. What do you want? Sense the mood and then some. Otherwise, we can issue notice, but that will be problematic.
Right.
You come here for a relief, you go with, losing whatever you have. That is not our spirit.
Yes.
That is not the way we work.
Time of life.
July.
24/7. Item 21. Sorry.
Side has not understood where I was hinting. First, that would be fortunate for you.
Item 21.
Yes, Mr. Taluka.
Maybe. My lord, what has happened, the petitioner pursuant to a regular selection, my lord, in 22, my lord, he was appointed as finance manager.
It's the same case where you had come.
Yes, that case, my lord.
You don't have a very strong case.
My lord, if I.
Or we will allow you. We are not stopping you. But for this kind of a case where you don't have, where you're on a very loose footing, you shouldn't have shown that interest. Anyway, let's see. Argue.
My lord, my respectful submission is the impugn order, which your lordship will find at page 89. My lord, it carries an element of disgrace, depicting, my lord, the qualitative shortcomings in the performance of the, my lord, duty of the petitioner. And thereby, my lord, this order is stigmatic in nature. Now, even being a, my lord, a contractual appointee, my lord, he has every right, my lord, to come out, my lord, without disgrace. And my lord, this. And
That's
this,
right. If they would not have, extended your term,
Yeah.
understandable. But this requires to be expunged. Not a disgrace, but then that's castigation of a kind.
And if your lordship, my lord, brings this into an order, along with, my lord, the show cause, your lordship will find, my lord, stigma is attached.
And your contention is that the single judge ignored all this
Absolutely.
and only read as per the terms of the
My lord.
conditions.
And the honorable single judge has held, it is not stigmatic at all. And my lord, honorable single judge also held that beyond 31st of March, there was no extension.
Reading whether to stay, we have to have a very strong reason for staying the operation.
My lord, recently in this kind of cases, your lordship has passed an order. I have gathered it. The honorable single judge, under such circumstances, when the order was stigmatic, my lord had directed.
Aware of those.
Yes, your lordship is aware that, my lord, I can
But
place
then
that.
the dominant purpose, the dominant decision-making ground would be termination, expiry of your contractual agreement.
That remains, my lord. But here, what your lordship say, that irrespective of the expiry of the term, they will take back him, my lord, conduct an inquiry.
We've done that in several cases.
Yes.
We have also refused in some cases,
Yes.
depending upon the fact situation of each case.
Yes.
Who are you appearing for, gentlemen?
Your lordship, respond numbers 2 and 3.
Who are they?
Is
The Assam State University.
University. You take a call.
Your
You
lordship,
respond to this.
your
In
lordship,
the meantime, you don't relieve him.
your lordship, the thing is, if I may take your lordship to page number 82 of the writ epic, clause 3 of the contract. It is not that the petitioner doesn't, the appellant doesn't know that there was no contract or regarding unsatisfactory performance or that the contract will be perpetual forever.
What are you? 82. 82.
82, clause 3. The term of the engagement shall be purely contractual and shall automatically.
Is he arguing on that? He's not arguing on
Your
that.
lordship, with regards to unsatisfactory performance, because there is a particular line with regards to unsatisfactory.
This is not simply sitter.
This is
Automatically terminate. If not terminated earlier based on unsatisfactory performance.
unsatisfactory performance. And that's why.
That's fine, but you proceeded based on earlier decision. You continued this, you tried to remove him earlier also.
Yes.
You should show cause and not, then you'll have to proceed on based on that. Not your ground is something different.
Your lordship, we have issued a show cause. If I may take your lordship to a show cause also.
My lord, in this regard, my lord, my respectful submission.
One second.
My lord.
you have to change the tack of your argument, not the track, but the tack. You have to argue with a different brush. Do it, Mr. Talukdar, then only we will be able to do it.
Yes. My lord will kindly see, had it been a case that I have been released for non-extension.
That argument we have understood.
Yes.
That you're on a weak footing, especially when we see page 82, clause 3. In fact, they could have said that it is automatic. There is no extension. Automatic termination of the agreement after 31st of May 2025. But because you were not terminated, there was no automatic termination. It was deemed to have continued, but then without any fresh lease of life. Now, this says that unless you have earlier been, a poor performer or conduct as solely determined by the chief executive officer, therefore now you can argue what we understand is that here it is you're being relieved not on the ground of expiry of the period of contract, but you're being relieved only on the ground of your poor performance or you're not having done something which you were under an obligation. For that, you were asked for an explanation, you gave explanation, but there is nothing in this order which says that was taken into account. You can only argue that.
I'm arguing that.
Mr. Talukdar.
I'm arguing that, my lord.
You're not arguing that, you're arguing something else.
No, my lord, I was coming to that. In addition to that, your lordship will find, my lord, from the impugned order, they say.
Respond in the meantime, you don't relieve.
Your lordship, if I may just submit one particular.
We have heard your submissions, but the order appears to be very cryptic. This is a dismissal order, not a relieving order. Though it is couched in such terms that it appears that because of the terms of contract being over, not extended specifically, you're removing it. But then that statement is preceded by 3 paragraphs where you hold him guilty. Now, have you taken into account his explanation?
Yes.
If you have, it doesn't get reflected.
Because the explanation which we have sought.
Therefore, Mr. Counsel, file an explanation, don't relieve him now. Till the next date, at least don't relieve him. That day we will decide.
One particular.
That day we will decide and we will ask Mr. Talukdar to go away.
Your lordship, if I may just. Because.
What is your name?
Your lordship, one more.
You are the lawyer for the Assam University.
Yes, your lordship, just one aspect, your lordship, just one aspect. Your lordship, just one aspect. Just one aspect, your lordship. Here, if I may just cite.
Because two options hai aapke paas. Either you respond to this petition, we have told you. You have a very strong ground. But till the next date, if you don't do, we will stay and fix it for hearing.
Just that the selection process for the selection of a new finance manager is over. Now, just because of the MCC.
So you take this ground?
No. That is the difficulty.
No, that's a big difficulty. We consider that. We will not be one-sided in our benevolence.
Somebody has been selected because our MCC could not be appointed.
See, you must give that credit to any bench, this bench of course, that we don't show one-sided benevolence. Correct. So at least 15 days you can hold back.
Yes.
Bring it on record that the selection process is complete, somebody is there, so there is no way in which he can be retained. We'll do that. But itna mehnat kiya ye bina certified copy ke order
I'm sorry.
he ran the risk of getting a very strong comment from the bench. Now again he has filed, he has mentioned 15 din ka to respite denge na.
I bow down to you.
I think you have understood.
Your lordship. Then, your lordship, nobody will be appointed. There's that no interim order may pass. I'll give an undertaking to this before the court that nobody will be appointed. The lordship may fix a date. I'll file a reply. Detail.
Till the next date.
Till the next date.
He shall not be relieved that way.
Yes. Not relieved. He has already been relieved, your lordship. He is not working.
He has already been relieved.
He is already been relieved. That's why after relief, he filed a writ petition. After relief. Now
you have already been relieved, Mr. Talukdar.
That is the difficulty.
No, there was a stay order by the Lana single judge.
Don't say you have already been relieved. Ask for his response and we will go to it.
My lord, while
anyway, you file your response, bring all these things on record, then we decide we are not writing it.
Yes.
Then there is no embargo also. Mr. Talukdar, difficulty. Had you not been relieved, You've got a letter of relief.
That is.
Oh, no,
interim order.
in fact, there was an interim order passed by the learned single judge.
That is
on
the
an
interim order,
settlement.
Your
From
Lordship.
there
That is what we have
itself,
challenged.
We will say, Mr. Bora. Mr. Bora, we will say that if not already relieved, he shall not.
He has challenged.
He was relieved, then there was an interim.
yes,
order.
my lord.
No, no.
Interim order was.
After he was relieved on 5th, Your
No,
Lordship,
no,
5th of June.
whatsoever, but
He
there was
approached
an
this court on
interim order.
24th, Your Lordship. He approached this court on 24th, just before the holidays. And interim order was passed on 24th or 25th. By that time, he was already relieved. So the honorable single judge did not pass an interim order with regards to his relief. The honorable single judge only passed an order that to carry out the selection process, but not issue a final order with regards to the selection.
There's no way out, but we will do one thing. Now, if you don't address yourself to the explanation offered by the person concerned, then it will be subject to the outcome of the resolution, any decision. That we will do.
Yeah, no.
This much protection we will give him.
Yes, Your Lordship may observe that. In the meantime, because it's a ADP funded project, we are having a lot of difficulties. Because this post of finance
All right.
is very vital, crucial. That's why.
Then we are not even doing that. Mr. Talukdar,
My lord.
you're on a very weak foot.
My lord will say only
No,
one.
for passing any interim order, we'll have to record his submissions. Why don't you do one thing? Now that you have heard the observations of the bench, you relieve him without this stigma.
I'll have to seek instructions on that, whether that will be done or not.
This is stigmatic. On this ground, we can interfere.
Lordship, Your Lordship, that's what I wanted to place a judgment upon the Supreme Court. Because the UP textile case, Your Lordship, it specifically held that this kind of end of contractual period will not be stigmatic, and that has been observed by a single judge.
No.
But at the same time,
No.
if I may-
It is very easily discernible that this relieving order is not because of the terms of contract. That's the secondary reason.
Lordship, then let me take instruction. Lordship may fix it on Friday. And in the meantime, I'll get instruction whether such kind of relief order, because he has already been relieved by the impugn order, which he has challenged. So he is no longer in the organization. So that is the requirement.
Say that it is not stigmatic. You substitute this letter with another relieving letter on the ground of no termination. Then perhaps he will have no ground to agitate.
Correct. And Deputy Prakash Banerjee, Your Lordship is aware, even if the order is innocuous, it has to be read in reference to the other orders proceedings mentioned in the impugn order.
Yes, for closing all his future assignments.
Yes, correct, Lord.
Without any inquiry, without anything.
Yes.
And you don't even address yourself to the grounds that he has taken. That's our only concern. We are being slightly more indulgent, Mr. Bora, but then what to do? You file your response to this petition. We leave it at that. Sorry, Mr. Talukdar.
My lord, correct.
No,
He's a young
carry-
boy, my lord, only my lord, with regard to his future prospect.
Take a-
This will come in the way, my
You're
lord.
not going to say all this.
Yeah.
But you take a call. Give him another letter. Withdraw that letter, give him another letter. It's correct. I mean, we cannot force an employer to continue with the contract. We cannot. We know our limitation. But of course, we will interfere if you be stigmatic in it.
Very well. I'll then have to consult with the
We
CEO.
give you 15 days. He has already been relieved. So there is no need for any entering order.
That's what I think.
Mr. D. Bora. Mr. D. Bora, learned advocate for the respondent number 2 and 3, seek some time to file response to this petition. Let this matter come of consideration on after 15 days. In the meantime, you have it processed so that we don't get an opportunity of, getting into the facts.
Till then, my lord.
Nothing, Mr. You have already been relieved. Till then what? Till then the status quo, you have been relieved.
No
Nothing.
price appointment, my lord.
No.
That is not yet made, my lord.
No, it's ADF funded, number one. Number two, the entire process has gone. We are only concerned that you should not be stigmatized. That's all.
My lord, what I want, my lord, on the next day,
No, Mr. Talukdar, this is an indulgence which we are not supposed to give.
On the next day. Next day you argue on that.
Next day you argue whatever.
yeah,
We are not giving any.
my lord, if your lordship says that, till then, my lord, they will not appoint. On the next day, your lordship can dispose it of. Otherwise, my lord,
That
he is also,
we were contemplating of doing that. We were contemplating of doing that. If you had not been relieved.
And secondly, during writ proceeding, the writ court allowed them to continue with the selection. So
And we don't find any fault with that. We don't find any fault with
if
that.
there would have been absolute stay continuing.
Even if we say or if we don't say, any decision, final decision, any decision taken by them would be subject to the outcome of writ petition. It has remained live with no embargo, with no handicap on either side.
that can be observed.
How can it be observed? These things are not observed. These are orally observed.
Highly obliged.
25-5. Item 23.
Urban flooding.
उसको भी उसी date में लगाना। Mr. Chamaria, we are hearing about artificial flash floods and everything on which date?
Next Tuesday, one item 15.
No, next is Tuesday is the individual cases. There was a case.
12-5. Next Tuesday.
PIL 14 of 24.
There is a matter in which AG is appearing and internationally acclaimed authorities have been called and they are suggesting something. If you know that date, we'll hear him on that date.
Mr. Ken Chaudhary is appointed as an amicus in that case.
I'll just check.
And in that case, all reports and everything is.
I know, I remember.
Not-
So some company from Netherlands has been commissioned.
Commission.
I'll just check up. I'll get this. I'll get it.
So, my lord, only one humble prayer, my lord, one interim prayer, my lord, page 24, my lord, just look, my lord, that the manholes which are kept open, my any rainfall, my any, my lord, a casualty again happened, my lord.
Ligo?
Page 24.
PIL 14 of 24 is that case, my lord. Item today it is listed. And Lordship speaks it on Tuesday. On
Page
next week.
24, my lord.
On 24. This for Tuesday?
PIL 14 of.
Mr. Nath, there cannot be any stopping. I mean, for no ground will stop from passing an order of closing all manholes.
My lord.
2 persons, 2 young children, 2 young boys have died. They have been drawn in that
Yes,
hole
very
because of the flash flood and their bodies were recovered somewhere else.
Somewhere else. my lord. Still, my lord, the position is not, my lord, I
Now,
think.
by Tuesday, I think you should be in a position to tell us that manhole has been closed.
Definitely. That
आप manhole हर जगह बंद करिए.
that will
My
be.
lord, page 24, interim page there.
Agreed, we have followed it, mister. We are keeping it on Tuesday.
Along with PIL.
Given that instruction to the municipal commissioner Gauhati. It should be closed. It's as urgent as anything else.
My lord, 3 units are required, my lord, the GMC, GMD and my lord, PWD. 3 departments is joined together.
We are keeping it on Tuesday. Mr. Chamaria should affirm that those manholes have been down.
Lots of are still open, even my area, man.
Let this matter come up for consideration on Tuesday.
12-5. Item 24.
Yes.
Remember in this case, Lordship, they were the last day directed to file the response.
It was not required. We said something, we were in a hurry, maybe it's not required. You have accepted the.
One of the orders they have.
You have accepted everything. You're getting every time that you asked for your dues, you have been given. Now you want the old pension. Is that correct? I don't think so. The appellant. Claims pension under the old pension scheme governed by Assam Service Pension Rules 1969. She is not satisfied with the limited benefits which she is currently receiving under the new defined contribution pension scheme of 2009, which is commonly referred to as NPS. And the subsequent office memorandum dated 14/1/2016, by which the provisional/extraordinary family pension has been extended to certain NPS covered employees who died in harness for the purposes of mitigating any family hardship. Next, the husband of the appellant had responded to an advertisement issued sometimes in the year 1999 by the secretary/superintendent of Purahuria Senior Madarsa in Karimganj district, and was placed at serial number 2 in the select list prepared after the interview. However, only with the intervention of this court, he stood appointed on 14/7/2005 and joined his duties on 16/7/2005. The records reveal that he served until he was transferred in the year 2012 to another madarsa, which was closer to his home, and which transfer was on the health grounds of was on his health grounds. The husband of the appellant died in harness on 8/3/2014. The school where the husband of the appellant was transferred was later amalgamated with Idgah High School. Because of the husband of the appellant having joined after 1/2005, the cutoff date for the new defined contribution pension scheme introduced by the state of Assam in line with central government's NPS applicable to recruits on or after that date, his service was covered under the NPS. Contributions were deducted from his salary. To stop the old Assam service bracket pension rules of 1969 did not apply in case of the late husband of the appellant. It further appears from the records, as also from the impugned judgment, that after the death, no retirement benefits were released to the appellant. But again, with the intervention of the court, admissible benefits under the NPS were released in favor of the appellant. There was no claim at that point of time by the appellant for being considered for pensionary benefits under the 1969 rules. The appellant had to approach this court again for family pension under the OM dated 14/1/2016. Which she has been getting regularly from 2014 onwards. The claim of the appellant before the single judge was that the respondents ought to have been directed, ought to be directed to consider the fact that she would be entitled for family pension and terminal benefits under the old rules of 1969 on the ground of delay in appointment, which was because of administrative faults and not attributable to the appointee. If the appointment had been made on time, the husband of the appellant would have been covered under the old pension scheme of 1969, old pension rules of 1969. The case of the appellant was dismissed by the single judge at the motion stage itself, holding that it was not open for the appellant to now claim for benefits under the old scheme, as it was never questioned by her earlier, and that she had accepted the NPS benefits, including the subsequent benefits which flowed from OM of 2016, which flowed from OM of 2016.
14/1/2016.
The issue raised by the appellant, the learned single judge held, the appellant, the learned single judge held, could not now raise the issue of her consideration for pensionary benefits under the old pension rules of 1969. We are in complete agreement with the opinion of the learned single judge. There is no merit in this appeal. The appeal is dismissed. Yes.
Item 25.
Wait, which item? My lord, here, my lord. My lord, initially there was an inquiry done, my lord. Page 102, my lord, regarding the damage caused to our land.
Required from a court. The court is directed for an inquiry whether you have suffered damages. The court has directed that if damages are established, the council will request the state government for allocation of funds. And the entire process has to be completed within a time limit. Don't you think your client is, asking for more and more?
My lord, my limited preamble.
I don't think we would have given this relief also.
My lord, first inquiry report, my lord, has attained finality, page 102. Now only quantum has to be determined. But by the.
Sorry, we don't find any fault with you.
Mr. Borua, better for you to wait for the result and then come back, take all these ground.
What do you want us to do?
My lord, let the.
Say that you must be paid for the damages.
My lord, my case, my lord, the NCUs have not done anything till now, my lord.
So that you go before the court. You withdraw this appeal, go before the court and say that your directions have not been there. File a contempt petition.
Partially a single just order, my lord. And the NC Hills have not done, neither any inquiry has been done, neither they. Let notice be issued, my lord. It's a case of, my lord, village compensation regarding non-maintaining of dumping yard. Our land has been damaged, my lord.
Mr. Parua,
My lord.
I think you're not understanding what we are saying. We find this petition to be absolutely without merits.
Well, may I draw your lordship, their page 145.
Nothing. Nothing has been done pursuant to the orders passed by the single judge. Go before him in contempt jurisdiction.
Or even if something is done which is not to your likings, or you can challenge again.
ये appeal क्या करेंगे इसमें?
No, my lord, the first inquiry report should be taken into consideration, but the fresh inquiry, my lord, that will again, my lord, not determine the compensation, my lord. That is without, my lord, the.
Sorry.
Lordship will consider one aspect, my lord. My ground, my lord, page 16, my lord. Page 16, my lord.
In fact, we would not have given you any compensation for the reason of the necessity. Many a times, while constructing road or while doing certain things, the debris has to be stacked somewhere for some reason. If there has been unfortunate, damage to your crops.
No, my lord, the highway has not maintained the dumping yard.
Is there any statutory rule made for compensation?
Yes, so that notification, my lord.
Notification does not have, it's not enforced. We are not inclined.
See, Mr. Borua, they have on their own, they have admitted that contractor has not followed the procedure, how to be done, and they got damaged. They had an inquiry, identified these people. First inquiry, you say that first inquiry is the correct. Then they had a second inquiry because Lot Mundal says somebody was not here. Now, court has said these to take an appropriate decision. Then also you can come.
Who will pay, Malo? That is the question. Now the highway has pushed the ball to the
state government for allocation of fund for compensation.
That is the difficulty. Now who will pay, Malo? That cannot be implemented. This judgment. Yeah, Lordship will, unless clarified and modified.
Mr. Borua, I think you have a standard. You have already allocated amount of money.
Yes, some amount of them allocated to ministry has discussed with the state government. We have allocated 32.16 crores to them. This is that now state government will assess the things along with demand.
You have already, allocated demarcated fund for enforcing this notification.
What have
Have you done that in this case also?
No.
Here not. Here actually what I read.
Mr. Borua, please respond to this question.
They have not said anything, Malo.
Mr. Barua, we are. When I read this brief, I thought I will impose first. You've got everything what you wanted.
Article. That's
The appellants had approached the learned single judge for a direction for payment of compensation on account of damage to their crops during the construction of National Highway 54 by NHAI because of the extensive earth cutting and consequent dumping of soil, as also the construction activities, the paddy fields of the appellants were badly affected. The irrigation channels were damaged. And even the standing trees dried up because of unregulated dumping of the debris. So all this led to the land becoming unfit for cultivation. The appellants and other similarly situated villagers had approached the authorities, including the deputy commissioner, the NHAI officials, and the revenue authorities of the North Kachar Hill Autonomous Council way back in the year 2013. The revenue department, according to the records, conducted a physical verification. It submitted an inquiry report in the year 2017, confirming the damage. Despite this, no compensation as yet has been paid. As yet had been paid. The appellants contended before the learned single judge that the NHAI and the contractor were solely liable for the damages caused. Damages for the caused. Taking note of the aforementioned contentions, the learned single judge directed the North Kachar Hills Autonomous Council to conduct an inquiry whether the appellants had suffered damage, and if it were found that the damage was caused to the crops and the land by the side of the construction site was rendered unfit for agriculture, a request be made by the Autonomous Council to the state government for allocation of funds to compensate them. The learned single judge also set a time limit of 4 months. Time limit of 4 months for concluding the process. Dissatisfied with the aforementioned direction, the appellants have approached this court, grieving that, in fact, no fresh inquiry should have been ordered, especially when, after a thorough inquiry, it was confirmed that damages were done to the land belonging to the appellants. And that the court ought to have directly fixed the responsibility on NHAI or the contractor for granting compensation. What leaves the appellants dissatisfied is that instead of directing the NHAI and its contractor to make good the damages by way of compensation, the entire process of compensation has been shifted to the administrative determination to the council and the state government. Okay. To the council and the state government. Only because he has also pointed out, Mr. B. Barua, Learned Counsel, has pointed out that during the course of hearing before the learned single judge, the NHAI actually tried to pass on the buck by relying on a state government notification of 2023, by which a damage assessment committee for claims relating to damages beyond the right of way which committee was constituted in another highway project and not another highway project, which had literally no application to the facts of this case. However, after having gone through the impugned judgment, we are of the view that the learned single judge correctly directed for conducting an inquiry and putting an obligation on the Autonomous Council, North Kachar Hills Autonomous Council, to seek state assistance in compensating the appellants. However, what concerns us now is that unless the state government allocates funds, the judgment impugned cannot be implemented. For taking the stand of the state, for ascertaining the stand of the state government, we have requested Mr. S. Barua, Learned Government Council, appearing for respondents number 1 and 3, to respond to this petition, to respond to this memo by the next date, re-notify us. Have you followed? Now you have to allocate some fund, because now the order has to be complied with. In fact, we have gone beyond our remit. We should have asked him to go before the learned single judge in contempt jurisdiction after the inquiry was over. But then just you respond on useless petitions. But you know, you can't just keep on discussing it.
34-6. Item 27.
This is the implementation of the basic scheme.
Mr. P.S. Barua. Mr. Barua, you have to give in writings that no person is in jail because of his inability to pay the surety.
That's okay. Already,
If you do that, you're in contempt of the Supreme Court.
already, as per the allegations that they have got that 325 inmates are in jail, but from the report that I have received, 52 inmates have already availed the
They may
facility.
be jailed for other reasons for their having not been granted bail or reprieve. But then, if they are in jail because they have not paid the surety, then instead of asking the judges not to direct for surety, you are supposed to make use of that money which has been allocated for this purpose. What have you done? Where is your statistics? Where is your report that so many under trial, so many prisoners who are languishing in jail because of their inability to pay the surety amount now stand released pursuant to the orders of this court? Where is that? Don't take it so casually. You are under contempt of the Supreme Court.
Yes, I have received the instructions, so I would like to put it on affidavit.
We want the numbers.
Numbers.
Which have to be verified by the counsel for the petition.
Numbers already I have received, but since it is a sensitive matter, so let me put it in affidavit.
There's nothing sensitive. I mean, sensitive about
Because ultimately it is with regard to the utilization of the money, which has already
this. Is not a sensitive matter.
Also,
No, I want a clear statement from the state Now, whether it is Mr. Barua or Additional Advocate General, or Mr. Nayak. Please come. We are roping in two of you. Not that Mr. Barua has not done his job, but today I wanted, the list of such persons who are in jail because of not paying the surety amount. That amount you have to pay. The central government has allocated funds for it. That fund lapses most of the times. Find out and tell us. We want a clear stand of the government. Otherwise, the direction from the Supreme Court is that you be held responsible in contempt of the Supreme Court order to be decided by us. Correct?
Yes.
So it is not sensitive. It is a serious matter.
Serious. Maybe the wrong use of word.
Mr. Nayak, you also look into the facts.
Yes, no.
For the reason of your holding a higher position in the hierarchy of government advocates. And you also represent the finance department. So we want a clear statistics from all jails. Not with respect to all. Where they have been granted bail,
Not really.
they're not able to come out because they don't pay surety.
Not.
I'm giving 4 weeks.
Just one aspect also. The legal service authorities has already furnished some statistics. According to it, 116 in.
Now let the state tell us.
Yes.
Services authorities also sought
Ms. P. Chakravarti. What is your instruction, Ms. Chakravarti? What have we said?
Given a details, my lord, district wise breakup, my lord. How many cases are pending? What is
Cases they pending?
Amount of money for which and my lord.
The moment you move the focus, we will not be able to do anything. Focus, Ms. Chakravarti. We want to know how many of the prisoners, despite bail orders, have not come out of jail because of non-payment of surety.
My lord, that breakup has been given.
You given that. How much is the number? Total number of the state.
Yeah, only a link to the night.
Yeah.
Some group 80, 180. This is 56.
Page 290.
Mr. Nayak, you just have a look at the affidavit filed by Ms. Chakravarti. There are many, and they are not being released because you are sending letters to the IZ prisons and all places. Now we don't want to hear all this. We don't want to hear.
Our instruction is concerned, 52 has in the meantime availed the benefit of it.
No, we don't want any to languish in jail because of this.
Yes.
We are not happy with number 52. Not even a single person should remain there because of his indigence.
Yes, no.
Indigence and not being able to pay the share. Correct?
You can go through this paragraph.
This affidavit by Ms. Chakravarti, you please go through and ensure that they are released.
Lordship.
We don't want any, logic or reason or any explanation. It must be done. जितना जितना list है उतना को तो आप बताइए that they have been released. IG prisons may not get time, but you are responsible to the state. IG prisons will come out with varied, explanations. We are not concerned. Money has been given to you by the central government. And what is this surety amount? 5,000 or 2 sureties, 10,000 or 2 sureties. What is that amount?
Nothing. Them are 5-10,000. Only 2 or 3 cases, 40,000.
They also have to be indigent to take advantage. And I don't think anybody, except for the ground of his poverty, would like to remain in jail for not paying. There are cases, because I come from a state where people don't pay surety for the reason of security. The moment they come out, they'll be killed by
family members.
internecine gang warfare. If that is the reason, we have no sympathy.
That is not the situation here, Lordship. Lordship will take up this matter after 4 weeks, Lordship. In the meantime, let me ensure what I can do.
Here, this is a very serious matter.
Lordship, unlike.
And on the next day, we would be happier if you say that no person on that account is in jail.
Definitely.
As prayed for by Mr. Nayak, Mr. P. Nayak and Mr. Barua. Learned additional advocate and government advocate. Respectively, let this matter come up for consideration on after 4 weeks.
24th July.
We'll get up for a while.
Yes.
What is the next matter? Manipur matter. And then? Mr. Chaudhary, you're here. Mr. Chaudhary, you're in item number 30. 30 and 31. We come back in 5 minutes. Yes.
Item 38.
May it please the court, I'm appearing for the appellants in this case.
Yes.
Yeah. Numbers, this is a case wherein the impugned judgment and order was passed by the learned single judge on the ground of the fact that the petitioner was approbating reprobate. On the ground of approbate and reprobate, saying that the petitioner had accepted his promotion and at the same time, he cannot challenge the same order. That is the finding and observation of the learned single judge, based upon which the said writ petition was dismissed. Now, assailing that single judge's order, I am before your lordships in this writ appeal. Now, the facts of the case, in brief, is that the petitioner.
We had heard it once.
Right.
And we had tried to know from you whether would you still like to. You have already been promoted, effective from a retrospective date of 12th of January 2022. Is that correct?
Right.
And that was also because of the sealed cover. There was a vigilance case against you.
Yes.
We are not doing anything. Anyway, you can argue, but prima facie, we are not. I mean, don't get very perturbed by the usage of the word approbate and reprobate. Now, there is no issue left for you. Who appears online? For whom?
Lordship, lead
please, Lordship, I'm appearing on behalf of respondent number 4, Lordship.
Respondent number 4?
Manipur Public Service Commission, Lordship.
All right. There's no difficulty.
Your Lordship.
Who is Mr. Stephen? You're appearing for whom?
I'm appearing for private respondent number 5, 8, and 9.
We are not. Let us tell you, we are not disturbing your position or your promotion. Now you tell us what you have to say.
Now
we are not gagging you. You can always make your arguments, but would it be of any avail now? We are not disturbing their promotion. We shall not. The question is that had you not been promoted, you would have taken into account. And you have been promoted not from a later date, but from a retrospective date, maybe not for that vacancy, 2019-20 vacancy. Then there was a sealed cover procedure. You were appointed. There was something vigilance case that was over. Now, should you be contesting this? I really don't know.
Our contention before this honorable call is that while we are not aggrieved by the promotion that has been vested to us, the seniority with which the private respondents have been placed above the promotees is what we're challenging before this honorable court. The primary ground here.
Was that the ground before the learned single judge?
Yes, that was the ground.
And what has the learned single judge held?
The learned single judge has held that since we accepted our promotion, we're hit by approbate and reprobate. Therefore, we cannot assail the same order by which we were promoted.
No. With respect to seniority. Naturally, because they have been promoted earlier. What is the purpose of keeping? Otherwise, also, you would not have been senior. Because you would have joined later.
No, but the reason, the contention is that these direct recruitees were not at all eligible for consideration in the said vacancy here. And that is also stated by the state in explicit terms in one of their communications, that these direct recruitees were not at all eligible. So they, despite not being
eligible on that particular cutoff date.
Yes.
For 2020.
Right.
they were required to have 17 years of regular service as section officer or assistant engineer with at least 3 years in the post of assistant engineer.
But that was for us. That was for
This
this.
was for you.
Yes.
And for them,
For them, 6 years. Brother.
6 years.
6 years. Because they
And
were
they would have completed 6 years when?
in 20, remember it's after the cutoff date of 1st April.
And they would have become eligible only after 5 months on 8/9/2000.
Right. So as on the cutoff date, there's no forms as regards the promotion, but in the subsequent.
And this date was fixed because there was no recruitment rules by that time.
Right. And the Department of Personnel has also stated that insofar as the current department, which is the Public Works Department, is concerned, the crucial date would be the 1st of April of that year. So these people, the direct recruitees, would become eligible in the subsequent year. We have no qualms with that. The only problem is that they have been adjusted against the vacancy year in which we have been promoted. Now, by that, the seniority has been disturbed. If they were to become eligible in the next year and been adjusted in the next year, then they would naturally come below us in the seniority list. Now, what has happened is that since ineligible persons, candidates, have been made eligible in the same vacancy year as us, now they have stolen march over us and are holding higher posts than the promotees. That much is the case, Malad. That much is the case only.
Yes, who appears for the state?
My lord, I'm for the respondent number 1, 2, and 3.
Yes. What do you have to say about seniority?
Only my contention is that because the applicant has accepted the promotion and it is challenging the same EPC.
It is argument. He does not question. He says that let the respondents, private respondents who have been promoted, direct recruits, he has no difficulty. But should his promotion be related back to the period of vacancy, which cannot, and why not, you have to tell us, so that he doesn't lose out on seniority. What is your ground? All this we have followed. Yes. We know. We have given you so many dates without the council telling us. You have come from Manipur?
Yes, I have come from Manipur.
Kenya Patel Mamata Kenya may lead the argument.
Who will?
She's online.
May please, Lordship.
She's from the commission.
Yes.
They are not concerned with commission now.
Lordship, commission is also involved with respect to eligibility. Lordship, we have submissions to make. Lordship. Yes, Lordship. Yes, Lordship.
We are not questioning the decision of the commission in considering them now. It is the question. I mean, yes. You tell us what is your response to this argument. You tell us.
Me, Lordship.
With respect to seniority, yes.
Yes, Lordship. Lordship, in fact, Lordship, in the impugned order, the learned single judge has gone into the maintainability, and on the principle of appropriate and reprobate, he has dismissed the writ petition, but has not gone into the merits of the case at all, Lordship. Yes, Lordship. Having submitted this, Your Lordship,
you want this case to be remanded to the learned single judge?
No, Lordship. No, Lordship. Because, Lordship, I'm rebutting on the contentions made by the appellant that the private respondents, that is the promotee, the direct recruited private respondents are not eligible. This is wrong, Lordship. This is wrong because...
To answer one question, what was the ground and what was the compelling necessity of, bypassing that requirement? They would have...
Lordship, we have not bypassed, Lordship. There are relevant recruitment rules by which the private respondents were eligible, Lordship, before the issuance of the office memorandum of 2022.
Can you just hear the bench first?
Lordship, I will, Lordship.
When I will say please speak, then you start speaking.
Lordship.
Because in VC, we must know. We also should know when to stop, when to begin.
Lordship, I understand, Lordship. I understand.
So unless you keep on talking.
Lordship.
Now they would have completed requisite 6 years of qualified service on 8/9/2020.
Yes, Lordship.
Correct? Factually correct?
Yes, Lordship.
But they were considered for the vacancy and for which the cutoff was 1/4/2020.
No, Lordship, because this 1/4/2000, this is my contention, Lordship. This 1/4, crucial date of 1/4/2020 follows from OM dated 10th September 2020, which is not applicable in our case. This is, and which is relying solely by the Learned Council for the appellants. This is our case, Lordship.
All
Because, yes, because they, because,
just a
may I,
minute.
yes,
That is a
Lordship.
ready-made answer, and that's a satisfying answer. Now,
Yes, Lordship.
this 1/4/2020,
Yes.
the appellant has brought it on record. This is, can we have this OM?
Yes, Lordship. It is at page number, Lordship. May I take your Lordship to page number 42 of the appeal, Lordship?
The two of the appeal.
Yes, Lordship. Annexure A2.
What is this office memorandum dated 10th of September 2020?
Lordship. May I read out, Lordship?
Just a minute. In supersession of all earlier orders, guidelines, notification to company of official date for the promotion of all sports and state government applicable RR of its federal sports to the RR and silent required rule. RR matlab hota hai? Service recruitment rule. That's silent. The crucial date for this person shall be 1st of April. Why do you say it is not applicable?
Yes, Lordship, because this rule says that if there is no relevant rule applicable for eligibility, then the crucial date will be 1st April 2020. Lordship. Because my contention is that there are rules, relevant rules applicable before issuance of this notification, and this is RR 2016 RR, Lordship. This is next page, Lordship, A3. This is the rule that prescribes the eligibility conditions for a promotion from AE to EE, Lordship. May I take your Lordships to page number, Lordship? Page number 49, Lordship. And because, Lordship, the subject contention is promotion to the post of executive engineer, and the method of recruitment, Lordship, this first number one, serial number one, is given by promotion, Lordship. Assistant engineer, surveyor, works engineer assistant with the following periods of regular service in the grade. In case of degree holder, 6 years, which is the relevant eligibility conditions for direct recruitee private respondents EE here, Lordship. So, Lordship, this rule has already qualified that 6 years is the length of service that's required for being promoted from AE to EE for the direct recruits. Yes, Lordship.
Passing examination.
In case of degree holder, 6 years.
Yes, these private respondents directly they are degree holders, because others is 9 years is but diploma holders. So these years are different depending on the nature of the degree they have for either it's a diploma or these degree holders. But whereas in case of the present private respondents who are direct recruits, they are 6 years, Lordship. So to that extent, therefore, Lordship, before the DPC, they were already eligible, Lordship. And secondly, Lordship, regarding another condition, Lordship, may I, Lordship?
1 second. What is in this 6 years would be counted till from which date?
Yes, Lordship. 6 years will be direct appointees were appointed on 8/9/2014, Lordship. So they become 6 years on 8/9/2020.
8/9?
2020. That is before the issuance of the memorandum dated the present 10/9/2020, Lordship.
That's all right. But
yes, and another condition is that, Lordship, yes, Lordship.
One by one. They were promoted against the vacancies of 2019-20.
20, yes. Yes,
so
yes.
If there is no fixed cutoff date, then any time between that year.
Lordship, because Lordship, may I another office memorandum I have to bring to the notice of Lordship.
Yes.
Lordship, as the DPC proceeding has stated that the DPC proceedings follows Office Memorandum dated 15 May 2024, which prescribes the normal procedures for DPCs. There, the applicable OM is that 2014 OM, where the crucial date is given as 1st October of that vacancy year. So
Okay.
by virtue, may I take your lordships to that OM?
Yes, yes. Yes.
Annex, page number 87, Annex X3 lordship.
Page number 87.
Yes, lordship. Lordship, this is Office Memorandum 15 May 2014, which is followed by all government DPCs for promotions to all government employees, Lordship. And para numbers, and this is the applicable OM, and which is also been subscribed in our DPC proceedings, in which Lordship, I'll bring it to your notice, Lordship. And para number, page number 87 of the 89 of this enacted lordship C.
Yes.
Crucial date for determining eligibility. The crucial date for determining the eligibility of officers for promotion would be is by applicable RR of the service or post. If the RR is silent, the crucial date for purpose would be 1st October. So, Lordship, it's applicable for us in both the cases.
All right.
Lordship.
All right, that's all right. Thank you, Ms. Mamata. Thinking that you represent Public Service Commission, we would not have asked you, but you have answered our query. Correct. We are satisfied. Yes. Yes, sir.
Now,
we are satisfied. It's all right.
Now, this office memorandum was issued in 2014. This was issued by the DP. Now, the next OM, if I may take your lordship to the OM date at page number 129. 129. 120. Learned Senior Counsel says that the second OM was issued on 10th of September. They had become eligible before that. But 129 is an OM which was issued before that. Now, this 129, your lordships in the kindly notice that this OM was issued by the same authority which published the 2014 OM. Now, what does it say? The undersigned is.
It's all right. We are not into that. Take up. We have heard Mr. A. Sahu,
yes,
learned advocate for the appellant, Mr. N. Anik Singh, learned advocate for response number 1, 2, and 3. Semicolon. MSO Mamata Devi, learned senior advocate for response number 4. Learned senior advocate assisted by Mr. W. Nagangom, advocate for response number 4. And who appears for response number 5? Mr. Stephen P. advocate for response number 5.
My lord. No, my lord, I'm appearing for respondent number 5, 8, and 9.
Mr. So-and-so, respondent number 5,
8, and 9.
5, 8, and 9.
5, 8, and 9.
5, 8, and 9. Taken. The dispute in the present appeal is with respect to promotion to the post of executive engineer, bracket civil, Public Works Department, Manipur. The appellant was initially promoted, paragraph change karna. The appellant was initially promoted as Assistant Engineer Civil on 29/12/2016. Later, the government of Manipur issued an office memorandum dated 10/9/2020, clarifying the crucial date for determining eligibility for promotion would be 1st of April of vacancy year, if the recruitment rules were silent. For the year 2019-20, for the 2019-20 vacancy year, comma, the contention of the appellant is that the crucial date would thus be 1/4/2020. Next. As per the recruitment rules of 2010-2016, comma, a candidate was required to have 17 years of regular service as section officer / assistant engineer combined, with at least 3 years on the post of assistant engineer. The appellant was appointed as section officer in 1987 and was promoted as assistant engineer in 2016. Thus, he fulfilled the criteria for promotion, for being considered for promotion before 1/4/2020. The grievance of the appellant, however, is that a DPC was held on 12/1/2022 for 34 vacancies for the year 2019-2020. The aforementioned DPC considered direct recruit assistant engineers of 2014 batch even though they had not completed the required 6 years qualifying service as on 1/4/2020. And they were recommended. According to the appellant, they would have become eligible only on 8/9/2020 and thus would have qualified for being considered from 1/4/2021 only and not for the 2019-2020 vacancy. The challenge to their promotion by the appellant could not be sustained. The prayers made on behalf of the appellant for quashing of the DPC proceeding and the appointment and the recommendation and appointments of private respondents, as also for, what did I say? What did I say? And for a direction for his promotion against 2019-2020 vacancy was rejected by the learned single judge, primarily taking into account that during the pendency of the writ petition, the appellant was promoted as executive engineer on 31/8/2022 retrospectively, but with retrospective effect from 12/1/2022. That is on par with private respondents. So this promotion was earlier kept in sealed cover because of a vigilance case against the appellant. The learned single judge had also observed, while disposing of the writ petition, that since the appellant had accepted his subsequent promotion order, he could not be permitted to challenge the same DPC proceeding which had benefited him. Thus, on the grounds of impermissibility of approbate and reprobate, the writ petition preferred by the appellant was dismissed by judgment dated 31/7/2024. Hence the writ appeal. Mr. Sahu, learned advocate for the appellant, after some arguments, limited his contentions to the extent of his seniority, without questioning, ultimately, the ineligibility of the private respondents in being considered by the same DPC. In order to overcome the objection of the learned single judge about his being a beneficiary of the same DPC proceeding in which he too was recommended against the vacancy year of 2019-2020. We are afraid the issue cannot be raised here in this appeal for the reason of inter-se seniority also being governed by specific rules, and which was not the subject matter or contention raised before the learned single judge, or contention decided by the learned single judge. Contesting the purported argument with respect to ineligibility of the private respondents, Ms. O. Mamata Devi, learned senior advocate for respondent number 4, drew the attention of this court to the office memorandum dated 10th of September 2020, referred to by the appellant, which clarified that the cutoff date would be 1st of April of the vacancy year only in the event of the recruitment rules being silent about the same. The recruitment rules Ms. Mamata Devi contends existed at the time of consideration of the private respondents as also the appellant. But with respect to promotion to the post of executive engineer / surveyor of works, eligibility qualification was prescribed without indicating any cutoff. However, according to the office memorandum dated 15th of May 2014, concerning departmental promotion committee and related matters, regarding instructions on departmental promotion committee and related matters, what did I say? Provided that the crucial date for determining the eligibility of officers for promotion would be as per applicable recruitment rules of the service. And if the recruitment rules are silent, the crucial date for the aforementioned purpose would be 1st of October. With the aid and strength of the aforementioned instruction by OM dated 15th of May 2024, the private respondents were also considered as they had already obtained the requisite qualification, the eligibility qualification of the requisite number of years of service at a particular post. Stop. In that view of the matter, having heard the learned counsel, the learned counsel appearing for respondents, private respondent, have adopted the arguments raised by M.S. Mamata, learned senior advocate. After having heard the learned counsel for the party, we are of the considered view that no rule was bypassed in considering the private respondents against the vacancy year of 2019-2020. For the reason of the private respondents / direct recruit assistant engineers of 2014 batch, as they had already completed the required 6 years qualifying experience prior to the date when the DPC could have been convened for considering their cases. Even otherwise, we are left with no option but to put our imprimatur to the opinion of the learned single judge of Manipur High Court of questioning the challenge of the appellant on the ground of impermissibility of appropriate and reprobate, for the reason of the appellant being the beneficiary of the same DPC. With the appellant having been promoted with a retrospective date from 12/1/2022, on par with private respondents, he ought not to have any grievance with the recommendation and promotion of the private respondents. The inter-se seniority between the private respondents and the appellant is a separate subject matter over which we need not, which ought not to detain us, at the moment, as it will be governed by the respective service rules, about which there is no reference in the impugned judgment. For the aforementioned reason, we don't find any merit in this appeal, and the same is dismissed.
Obliged, Lordship. So much obliged, Lordship.
Careful.
For hearing, item 30 and 31.
The Lordships may recall on the last occasion.
Yes.
I had made my submissions, but if your Lordship so desire, I can repeat.
Cases only come at 1 o'clock when we are just ready to, always. And you're not ready for argument after lunch.
I am at your Lordship's disposal today.
With some difficulty.
No.
Huh?
It appears my Lord Justice Chaudhary.
No. These are just off the.
If your Lordship so desire, I can refresh the facts.
No, your argument that time is very live in our minds.
Well,
you are questioning the validity of sub-rule 3 of Rule 20 of the Assam Local Fund Audit Service Rules of 1995, which mandates that promotion shall be given only on the basis of only from the select list whose lifespan would be 12 months. And you say that it is destructive. I mean, I don't think so. Otherwise also, suppose you pass. I mean, the question which comes to our mind is that suppose you pass some examination which makes your, by which your name is entered in the select list. Now, suppose there are not many vacancies. If it is pursuant to and against particular number of vacancies, good enough. It is understandable that for some reason, because of court case or something, appointments, promotion cannot be done. It should not lapse. But if it is a general promotion, not correlated to the number of vacancy in the promoted post, and that list remains, I mean, it is not acted upon for whatever reason, it cannot be allowed to remain alive for perpetuity. Otherwise, the entire service jurisprudence with respect to promotion would get a jolt. Now, so far as constitutionality of this provision is concerned, you need a very, very strong reason for us to question the wisdom. Now, a provisional list, as you would have seen in most of the cases which have been decided on this aspect of the matter, they say that if you don't specify as to for how long a provision, a select list would remain alive, that would be against the very spirit of framing any service rule. Now, in this background, you have to proceed your act.
My submission.
I think we have not forgotten what you argued on last.
My contentions are threefold. Number one, if we do a literal interpretation of sub rule 3 of rule 20, the effect thereof is that here is a case where it is a examination based promotion, not a vacancy based promotion. It would leave a direct recruits select list alive in perpetuity. Whereas making this list, which is a...
Give us any case law. Give us any reference.
I have gone through all the cases that your lordship has referred to, that a select list has to have a life. These pertain to either direct recruit or normal procedure of promotion. Here is a promotion which is a departmental examination based promotion.
Correct.
Your lordship.
Correct.
That is my first content. I'll elaborate on those.
You will have to support this by case law, because prima facie we are not getting persuaded.
But the reason is, I'll come to that.
You could argue not on the constitutionality, but on special feature of this case, because there was vacancy, you would have appointed, but for some objection by some of the failed candidates. Correct. So that's a different issue. But that would not entitle you to question the constitutionality or the validity of the rule.
In
that case, the challenge would be before a learned single judge, and not the constitutional. No. Unless you come up with very strong.
I'll come up with a case law. But before that, two other aspects I must point out to you.
Would you continue after lunch or another day?
I'm here.
Inform the council for the criminal case also, that we will or they come here at 2:00. At 2:50. I think, Mr. Chaudhary, you would finish your argument.
I will not take more than 15 minutes.
Oh. On. Keep your case laws ready. Mr. Naik, you also have your...
Yeah, I have two case law topic. Even if it is not mentioned in the rule lordship, generally it is 1 year. That is the law settled by the Supreme Court.
No, that's right. He says that in such a select list, which is departmental examination based, then would he be required to pass another examination? Now, in that case, he questions the correctness of this rule, saying that, well, I have passed examination, this time I was successful. This was against the vacancy, it could not be acted upon for some reason or the other. In the next examination, I may not pass. That's not a very strong reason.
Yeah. I'm not required to, under the rules, I'm not required to appear in any exam any further. That is a provision in the rule. That was the second limb of my argument.
Then where is the question? Why do we question it?
Because they are not refusing to appoint me.
No, if there is a rule, they can't refuse you, then you can't challenge it. Then you go before the learned single judge that they are wrongly applying this rule.
Yes, Lord, that is what I am submitting, Lord. During the pendency of the case, Lord, if select list was declared invalid, Lord, they are not agree against that.
No.
They think the rule is against.
There is no order making the select list invalid.
No, it says that panel may have gone bad, gotten stale, but then he would not be required to pass another test.
Very well, Lord. Look, why?
So otherwise also, if the next list is made,
Yeah.
those who have passed one examination, they would be considered or would be deemed to be part of the select list every time.
Then validity should
That,
be the
that cannot happen.
Then validity is not the appropriate provision.
No, that validity or not, that
there is other provision.
then it becomes very, very difficult. This cannot be sustained.
The provision that has
Let's see. We'll come back.
Item 32 for delivery of judgment.
Mr. Boyan, we'll take about 10-15 minutes and then we shall get on to. We have called you to be on the safer side because of some impending function, we might have to rise at 3 o'clock. In that case, it will spill over to another date. But then just be here. Let us first conclude with Mr. Chaudhary and Mr. Naik. Yes. What is this delivery of the judgment? Yes. Anything that you have to say?
Yes, my lord. Yesterday, Mr. Das submitted a judgment of the division bench of the Mumbai High Court. The Bombay High Court relied on the full bench of the same court of a judgment which has been also relied by the Karnataka High Court.
That's right, Mr. Nath. We have not gone on any judgment of any court. We have gone on the rules which Ms. Gayan had shown to us, the requirement, and a harmonious reading of the provisions contained in section 70 and 75 of the Railway Pension Rules 1993.
Yeah.
So therefore, the expression wife and wives or widow/widows is referable to only such persons where polygamy is permitted. And even in such situation, the consent of the surviving partner for marriage and the permission of the employer, that is the railways, have to be taken.
Yeah.
So on that we have gone and we have decided.
I just pointed the Karnataka High Court that I judgment I have given. They are also, my lord, my submission exactly that way.
We have gone on the basic principle. So we have said that the son would be entitled, but she would not be entitled.
Yeah.
I think that's the anyway.
That's will be entitled from that date of the after death. Area.
Mr. Das, we have recorded your contributions as a amicus. The clincher was what she pointed out. Otherwise, therefore, the requirement of reading it that way.
Yeah. All right.
Item 30 and 31.
If your lordship permit me,
let
I just briefly summarize.
Come to the rules.
Well, your lordship will come to page, starts at page 53. Page 53. The rule that is relevant is at page 60. Rules 17, 18, and then 20.
These are called the Assam Local Fund Audit Service Rules of 1995.
Right.
So the relevant portion would be
Page 60, rule 17. So it is 75% by promotion. Sub-rule 1 says, sub-rule 1 of 17, 75% of the vacancies in year of recruitment in the cadre of audit officer shall be filled up by promotion of assistant audit officer who qualify in the departmental examination called the Assam Local Fund Audit Service Promotion Examination. And then Sub-rule 2, an assistant audit officer to be eligible for appearing in the said examination shall have to complete at least 3 years of service as assistant audit officer on the first day of the year of recruitment. And this sub-rule 3 is most relevant. The fact that it is purely a examination-based promotion. The Assam Local Fund Audit Service Promotion Examination shall be conducted by the Commission in accordance with the rules and syllabus as in Schedule 3 and shall be held at such intervals as the appointing authority may in consultation with the Commission from time to time determine. So that it is not every year. A list of candidates who have qualified in the said examination shall be prepared by the Commission in order of merit and forwarded it to the appointing authority. Promotion shall be made from the list subject to availability of vacancies. Now, sub-rule 18 provides for direct recruitment. This is the normal procedure. 25% has to be done by way of direct recruitment. Now, the problem that arises is there is no time limit for the direct recruitment, which is an open source recruitment, whereas an internal departmental examination, this embargo of 1 year is at sub-rule 3 of rule 20. So that is the absurdity that has stepped into the rule. And that absurdity is further fortified.
Page 62. Rule 20 and rule
Page 62, rule 20 starts. Sub-rule 3 only provides for 12 months validity for the examination held under 17.3, but no such embargo under it for direct recruitment. So that is the
Now, where's the provision about which you were referring? Just
my lord will, if your lordship comes back to sub-rule 3 of rule 17, it refers to the syllabus in terms of schedule 3. And if your lordship comes to schedule 3 at page 69, your lordship will find that minimum marks is given, and towards page 69, towards the right-hand column, your lordship will find percentages of exemption marks. So anyone who secures this exemption marks, in other words, passes in this particular paper, is not required to appear any further, which your lordship will find.
How do you read that?
Well, next page it is provided at the very top.
Yes.
Next page, page 70, at the very top.
At the very top.
Page 70. No book will be supplied for any paper, any candidate failing an examination, but securing exemption marks in a paper will not be required to appear in that paper. So we are people who have passed in all the papers and got exemption marks.
Not be required. It will not be required to appear in that paper.
So we have passed, got the exemption marks in all the papers.
But then if the list itself vanishes,
no,
then whether you have got exemption or not, that doesn't make any difference.
No, the other contention is that is how the state has always understood, because they hold the examinations every 5-6 years, and they have always, whenever they have published a list, in spite of expiry of 1 year, they have proceeded to appoint. We have annexed all those documents.
They have proceeded to appoint.
Yes.
Then what is your problem then?
In our case, they are all of a sudden they have come up with an affidavit saying that the list has expired. When this particular advertisement itself was operated almost after 4 or 5 years. I will place that. Your lordship will just take note of 2 dates. On 3/5/2018, on 3rd of May 2018, the advertisement was published. The last appointments were made. The select list is dated 7/11/2019. And the last appointments were made on 24/9/2021 to 5 different.
Last appointment was made on?
24/9/2021. And in fact.
This is from the same select list of 7/11.
Exactly. And in the previous years, the first time advertisement was issued in 1999. And appointments continued to be made for almost 4 years.
Is that correct, Mr. Nayak?
And
but why are you stopping them from being considered?
Because it was, result was declared in 2019 law, and decision was taken not to give validity any further law. It was taken in the year 2023 or 24.
No, 25. 25.
Why that decision was taken when in the past?
Because in the meantime, not many candidates became eligible now. So we cannot wait till for an indefinite period.
And where is that? Then how do you justify the past actions of your appointing from the same select list after 1 year has passed?
Lordship, that is why, Lordship, on last date also I repeatedly submitted, Lordship, this rule has always been interpreted in a manner favorable to the petitioner.
But this time you're not.
Because certain time limit is there. Lordship, we waited till 2025. Since 2019, we waited till 2025.
That's a self-defeating argument, no? That's a self-defeating argument.
In fact, that is the stand taken in the affidavit. So I can't improve it.
You can't improve upon the facts of the case, but you can definitely, change your stand. That stand is absolutely not acceptable because it doesn't make sense. Then in that case, you'll have to justify and you'll have to say that because in the previous years, there were not many vacancies and there were not many people who were to be accommodated. But now with the onset of new regime or same rule, but circumstances today is such.
That issue was not raised earlier.
Separate examination is to be held.
Yeah.
So separate examination you hold, there is no difficulty. But there, those who have passed exemption marks, accommodate them.
Lordship, my learned colleague
in fact, we are
has
faced with
raised
such
a
a
relevant rule, Lordship. He read the rule, probably it was for the assistant audit officer. I am reading the rule at page 73.
I try and understand what we are telling.
Yeah.
We are telling you that we do not find any anomaly in 20 subclause 3. Individually speaking, leaving aside other facts, what is it called? Ceteris paribus, we say that this provision is all right. A select list has a life. It should not have an unlimited shelf life. It has a life. So far, so good. We don't question it. But you have been using that list beyond the life for appointing others or for promoting others. But this time, I don't know because of which number, what compulsion, whom did you want to include, whom do you want to exclude? You say that this will be operative proprio vigor. Now, this is our only objection. Our objection is not to the constitutionality of the rules.
My submission remains the same. Since 2019, we waited till 2025. The matter was pending before the High Court. So that is why no effect was given to that rule of 2023. But we waited for 6 years, Lordship. In the meantime, many eligible candidates there were.
But this litigation
we have to accommodate them also.
So you do what? Could you not have thought of a better way of justifying your past action? You see, it's not.
Lordship, that issue has raised now, Lordship. If something wrong was done in the past, Lordship, and that will not be justified now.
We are not going to tell you this. that because wrong was happening in the past, therefore this wrong also should be perpetuated. Are we asking you this? Now, the reason why you say that we will give full, application of 20 sub clause 3 of the rule is because of number of persons becoming eligible. How do they become eligible without passing the examination?
No.
They can't. You have to hold an examination.
Lots of the qualifying eligibility is 3.
Therefore, where is the provision? How do you justify putting them to further examination with this? But securing exemption marks in a paper will not be required to appear in the paper.
Page 73. Page 73. Actually, this is the provision for audit officer. The one read by my learned colleague is not the provision for audit officer.
No, Rule 17(3) speaks about Schedule 3. I read up.
Page 73. Notes may kindly see the heading. Rules and syllabus for the audit officer examination. Lordship, it comes to third column, fourth column and fifth column. One column is there, maximum marks required for passing. That is 40%. Lordship, may kindly see the next column, percentage of exemption mark. Now, if Lordship comes to the next page, top. No book will be supplied for any paper. Any candidate failing, that is, here failed to score 40% mark in the examination, but securing exemption mark in a subject will require to appear again in that subject. Paper 1 and 1 to 2 should be treated as separate subject, or in other words, only candidates who obtain 50% marks or above in each of these papers will become eligible for exemption.
Exemption from what? From appearing in the
again.
Examination.
Yes. So passing is not the criteria. For exemption, you have to score at least 50%.
They say that they have obtained 50% marks in all subjects.
I'm not aware of that point. Lordship, I have not taken any instruction. If they are saying, probably they may be correct. But for passing, it is 40% only. So to pass the examination, it is required 40%.
You understand that? But suppose Mr. Chaudhary's statement is correct, that they have passed and they have obtained 50% marks in all such papers. Would you still exclude them?
Difficulty is this provision is for those candidates who fail. Lordship will read the first line once again.
It means
who fail.
Person who fails gets the benefit, person who passes.
Any candidate failing.
You are not rational so far as this aspect is concerned. We are not getting any light from, assist us in a proper way. Don't take a stand. We are not asking you to concede, Mr. Naik. Please take it from us. No. It's your case. It is your state. It is your rules. But what you're talking is completely dichotomous in its import. I don't know why do you have to always repeat that my stand remains the same. We are not testing your chivalry here. Don't treat it as a chivalrous act of saying that whatever wrong or right we have done, we abide by it. वो कहीं बाहर दूसरी जगह करिएगा कि what I say I do. Now this is a place where logic has its importance, where reasoning is important.
Yeah.
Therefore, now you tell us one thing. In the event of a person claiming to have obtained exemption marks in all the papers, and that list having expired, would you subject him to another test undertaken for the purposes of promotion? ये सवाल है. अब इसमें मेरा स्टैंड पहले वही है, बाद में वही है. I don't think it answers our query. Now, would you subject him to a departmental exam? Say yes. We return the brief of Mr. Chaudhary straight away for him to go before the signature.
What I suggest, Lordship, there is a relaxation clause in the petition, in the rule law. If they are claiming that I have scored exemption mark, let them file one representation before the authority, because going strictly by the rules, Lordship.
You make a statement.
Lordship, I cannot go beyond the rules, Lord. That is my difficulty. Here it is clearly mentioned that, Lordship, those who have failed.
You don't go beyond the rule.
Yeah.
But you will definitely make a statement that in case they have got exemption, in all papers, and that list unfortunately has expired for no fault of theirs, either it is because of no vacancy, or they're not being found suitable?
Vacancies were there. That is, I'm submitting law. Vacancies were there. That is why I'm saying why you are challenging the rules. You challenge the decision of the authority declaring the select list invalid.
They are challenging it because of your stand, which is not.
There is no fault in the rule, Lord.
Which is not intelligible enough. Your stand is very unintelligible. We don't understand your stand. That is the only difficulty.
That is.
Otherwise, we would have straight away relegated them to single judge. No difficulty. Your stand is something which creates confusion. And this confusion would stand perpetrated. And in that case, you will not be able to.
And they have not passed any order declaring it as invalid.
He's not understanding what we are saying. पहले तो दिमाग से ये हटा दीजिए. Let you not have any confusion in your mind that we are asking you to go beyond the rules. We are not. We are not also insisting. We don't ask you to concede. After having said that with so many caveats and disclaimers, now can you say something which is amenable to logic? Now, question is this. Rules are very clear. The list expires. In the past, you did not give effect to that provision. Not for the reason of helping anybody, but this time you are enforcing it on the specious plea. Specious means it's a substitute for the word spurious. An unacceptable plea that there are many eligible candidates. So far, so good. There are many eligible candidates and there are many vacancies. Now, with this clause again of an exempted person not necessarily be subject to another examination, once you say that this is available, the rule says so, then we close this chapter totally. We say that when you're not considered, they come back to us. You have to make a statement. You can't say, let them file an application. That kind of an approach, Mr. Naik, that is against the litigation policy of any state.
I'm saying because without an application, that relaxation rule cannot be applied. Or lordship will direct relax the rules. Yes,
जहाँ हमें direct करना होगा, वहाँ मैं direct करूँगा. We don't require any concession of any party.
In that situation, lordship will again read page 74. Again, that provision, any candidate failing, only they are eligible for exemption.
You're additional government, additional advocate general, therefore we are not we are asking you to go for further research. You tell me one thing. You just take instructions that in case any candidate whose name was there in an earlier list, which list with the flux of time has gone bad. But if he has obtained exemption marks, that is 50% and above in such papers, would he be required to appear again in an examination? We are not asking you to give them appointment. Yes, because the rule 17 only says that your name being there, a candidate's name being there does not give them a right. It does not confer a right on appointment or promotion. The authorities, the authorities will consider the suitability. But suitability of only those persons will be considered who form part of that select list. The moment you say that, we close the chapter. We are not finding any fault with the rules. I can't employ more simpler language to explain this. Because neither are we going to pass an order in anger, nor in exasperation. If you say that, no, you pass an order, we will say that because we did not get assistance, I am passing this order. Because this is how I understand. So please, that's a rule which is practiced in all courts. And I think I being senior to you in age, not in the capacity of Chief Justice, but senior to you in age, I can tell you that that is not the way you address the court. Now, this is an argument. What kind of an argument is this? Now, I can't go beyond this. If you think that he deserves, you pass an order. That's not done. That's not acceptable to us. Why should we pass orders beyond our...
If that is the impression I conveyed, Lordship, I apologize for that.
But what I'm praying only
See,
for a healthy.
we are not going to pass any order beyond our remit. This I keep repeating, that we understand our limitations under Article 226.
No.
It is self-imposed limitation, we do it. But don't force us to say that because this question was not answered, therefore we say that we consider. I mean, that is not a good day for justicing.
Yes, Lordship, I'm ready to take that instruction. Let me have that instruction.
Take that instruction. There is no hurry. There is no hurry. Take the instruction. And I think the instruction has to be on a very simple terms, not in different variables.
Yeah.
Any person finding his way in the merit list, in the select list of a year, having obtained exemption marks in all papers, would he be required to sit in another exam? Lot simple. You say yes, you say no, we accept.
Lot.
Correct?
Yes.
When will you do it?
1 week.
देखिए, कभी भी the beauty of law and practice is this. These are no set of ironclad rules. Had it been such, you would not have agreed for, in no circumstance agreed for keeping the list alive even after the expiry period. You've done it. We are not asking you to do it again. We are only seeking a correct explanation so that we collate all facts and decide that, well, prima facie, the Rule 20 subclause 3 may not appear to be bad, but in its working, with another exemption clause being there, this appears to be unworkable. And therefore, in order to bring clarity in the recruitment process, I think it has to be read like this. But clear है, आप कह दीजिए कि साहब जिनको exemption हुआ है उनके लिए list expire करे नहीं expire करे मतलब नहीं है. He will be part of another list where he will not be required to write an examination. Does he have any right beyond that? Nothing. And then don't find him suitable, reject him. That will be another cause of action. But for this rule to work, you must explain the exemption clause along with 20 subclause 3. That's a simple proposition. Correct. Do I dictate it?
Yes, Doctor.
Do we dictate it?
Yes.
Right.
On the merits matter, rest of the submissions I'm reserving now.
No, there is no reservation.
There are just a few judgments that I.
Mr. Chaudhary, that we will not permit you to do that. The moment you lose, I mean, if the constitutionality, otherwise, your argument has to be limited to the redundance of certain provision in the rules for saying that 20 subclause 3 is bad.
No. There are two aspects.
No argument हम नहीं सुनेंगे. Then I relegate you to the single judge. Because we have our own limitations, no?
No.
Why do we exercise that jurisdiction which is to be exercised by a single judge?
No. If I challenge a rule, madam, just let me clarify. Perhaps I have not been able to make myself clear. One limb of my argument is that having put an embargo of 12 months on an internal departmental examination, which says that the list will be appointed subject to availability of vacancy, whereas for a direct recruitment, it leaves the list open in perpetuity. So there is an absurdity that has crept into the rule.
This is your argument, then we don't require any clarification.
That is my alternative argument.
That is your, just a minute, if that is your argument, then we hold the distinction to be correct. And we say that the rules are, it draws the constitutional muster. अरे साहब वो फिर Article 14 के classification पर हट जाएगा अलग. This is so mathematical, Mr. Chaudhary. Where are you going astray?
But the other thing is my alternative.
Make that argument, Mr. Chaudhary. It will be convenient for us. We will say that this distinction has been pointed out. Which distinction has the muster of Article 14? Because direct recruit and promotees constitute two different classes. And therefore, this equality is misconceived or lack of it. आप बताइए इसको मैं इसको constitutional करके अभी खत्म कर. Tell us. Your argument has to, you see why we have entertained this petition now, because you say that in the past, despite the flux of time, the list was acted upon.
That is my second limb of argument. I appreciate.
That is your second limb of argument, then perhaps that is, we consider it to be the only limb which we can take into account.
And in support, my lord.
Both of you have, I can accuse both of you lawyers of making the court talk more. Unnecessary.
That should be considered as an achievement, my lord.
You have wasted the lung power of the court
That's
for no apparent benefit.
That should be considered to be a achievement.
आप वो argument अगर करेंगे, then we will be forced to say that we don't find anything bad in this. So far as distinction between promotees and direct recruit is concerned, it is 100% justifiable. Under Article 14, we have hundreds of case laws which says that this distinction. हम उस पर है ही नहीं. I understand.
I appreciate what has followed.
We are only not finding logic in what Mr. Nayak is saying for the reason that he says that up till now we have been doing it. From now we shall not do it.
All along.
तो फिर आप उसको second argument बनाते हैं.
I'll reverse it now. Right? That is my point.
And on top of it, you have shown to us that exemption clause.
Yes.
So if that exemption clause also, Mr. Nayak can find out an argument to offset your argument. He can say,
if the state wants, they can always
to assist you here. You have another ground up your sleeve. You are not taking that ground.
I have taken that.
No,
this exemption clause is applicable only for failed candidates.
I'm telling you another ground which perhaps would not have caught your attention. You can say that this exemption clause and not writing paper is with respect to a candidate again filing during that year when another examination is there. You can say that. ये कैसे होगा कि list expire कर गया उसी में बना दे? आपकी list, the way you have formulated your rules is absolutely faulty. We might, because the law says that the judges should be very loath in questioning the correctness or the wisdom of the legislature, unless it makes the working completely difficult, anomalous.
Probably I am unable to convey myself, but I have very much sympathy with this petition.
No, don't keep sympathy.
And I'm trying to help them, Lordship, because of these issues, Lordship. Even I had a discussion with the secretary also.
Let the sympathy thing work here. For you as an officer of the state, as a law officer of the state, you must be a strict administrator. If he doesn't deserve, he doesn't deserve. Finished. Don't have any sympathy, sir. He's not an indigent, landless laborer by the vagaries of nature whose land has been swept off by the river, and then he wants a patta on the village grazing land. Wahan sympathy rakhiye to rakhiye. Yeah, he is an officer. What sympathy?
In the process, they have also lost 6 years of
any litigant employee. Does he require sympathy or does he require adjudication of his rights? He doesn't require sympathy. His rights are given. आप इतने केवल हमें बताइए कि whether the exemption clause would apply, notwithstanding the influx of time. Simple line.
Lordship will add one more word. Whether the exemption would also apply in case of candidates who were declared pass, not fail. Because to my understanding, this provision applies only to the candidates who fail, whose name did not appear in the selected.
Do you take two examinations? Do you take compartmental examination?
In the subsequent examination?
Subsequent is different. That's new year. If you take compartmental examination and you give the candidate who fail another opportunity to be listed in the same list, then your argument is correct. वो है तो नहीं? That is not there. कहाँ confusion create कर रहे हैं?
Will not be required to appear again in this subject.
Again in this subject when?
The time frame is not here.
Then would he
definitely in the subsequent examination?
Would he not be entitled to argue that there is a lot of confusion, there is a big hiatus in the rules, and therefore capable of being misread unless clarified? And in that case, you can't take the plea that, well, we will not clarify, this is the rule. You can't take it. इतना पता करके बताइए. He's interested in getting promoted, not setting aside the rules. In that case, we will immediately close this, saying that there is no reason for us to question the correctness or validity of the rules. It is with respect to working of the rules, and if he's aggrieved because of his not getting the exemption, notwithstanding the flux of time, he can approach the second bench. Simple hai, isme itna time
I think there is an earlier single bench judgment denying this based on rules, isn't it?
No, there is a judgment on a different subject matter pertaining to the same selection.
WBC 9305
Yes,
2019.
that is on a slightly different issue.
We have heard Mr. Indranil Chaudhary, learned senior advocate for the petitioner, and Mr. P. Naik, and Mr. P. Naik, learned additional advocate general for the state of Assam. The petitioners are assistant audit officers working in the Assam Local Fund Audit Department, who claim to have cleared a departmental promotion examination which was held in the year 2019. Under the existing service rules, namely the Assam Local Fund Audit Service Rules of 1995, bracket hereinafter referred to as Rules of 1995. Once candidates pass the examination, their names are placed in a select list. Rule 17 of the Rules of 1995 further provide that promotion to the higher post of audit officer would only be made from this select list of candidates as and when the vacancy would arise. A difficulty has arisen in the case of the petitioners. For the first time, because of the operation of sub-rule 3 of Rule 20 of the Rules of 1995, which provides that the select list referred to above, which shall be prepared after a departmental examination is conducted, will remain valid only for 12 months from the date the Assam Public Service Commission approves it. This necessarily implies that after 12 months, the list automatically expires. Next, in the case of the petitioners, despite there having been placed in the select list after successfully clearing the examination, departmental examination, no appointments could be made, perhaps for a court case, within 1 year. To stop later, even with the vacancies, later with the remaining what did I say? Last line? Last of the lines.
Just one factual aspect of it. These appointments have been made. We are the ones who are left out. There were several appointments that have been made.
With respect to you, yes. The appointments of the petitioners could not be made, perhaps for a court case remaining pending. So later, the claim, the allegation of the petitioners is that they are not being considered for the vacant position for the reason of the time efflux, whereby the select list has lost its life after 12 months. While saying so, Mr. Chaudhary, learned senior advocate for the petitioners, has submitted that all along in the past, notwithstanding Rule 20, sub clause 3 of 1995 rules, of the rules of 1995, the select list for all practical purposes remained alive, and appointments were made from such list, even with the efflux of time and the list having expired after 12 months. It was only on this occasion that the stand of the respondents is that section 20 sub clause 3 clearly bars the validity of, clearly spells out that there shall be no validity of such select list beyond a period of 12 months, the date to be counted from the date of the approval by the commission, by the Public Service Commission, by the Assam Public Service Commission. It has further been pointed out by the petitioners that Rule 17, 2 of the 1995 rules rule uh, 63. Which page did you point out that exemption?
69. Schedule 3. Rule 17 refers to Schedule 3, and the relevant portion is at page 70. Schedule 3 starts.
How have I ended the last paragraph? Approval of the list by Mr. Chaudhary, however, has pointed out that Schedule 3 appended to the rules of 1995 clearly provides that any candidate failing in an examination but securing exemption marks in a paper will not be required to appear in that paper. The connotation of this provision would be that in case a candidate passes the departmental examination and obtains exemption marks in all the papers, he shall not be required to, in future, sit for any other departmental examination. Full stop. This provision comma, if meant as is projected, if this provision, if meant as projected by the petitioners, would only render Rule 20 subclause 3 otiose or non-functional. Or non-functional. Mr. Chaudhary contends that the provision in the schedule is very clear in its import that in the event of a candidate having obtained exemption marks in all papers in the departmental examination, comma, even with the efflux of time and the validity of the select list expiring, comma, there would be no requirement of the petitioners of such persons to be subjected to another departmental exam, who shall automatically form part of the pool from where promotional from where promotions can be made. Promotions will be made. Promotions shall be made to the higher post of audit officer. Countering such argument, Mr. Nayak, however, has submitted that the aforementioned provision in the Schedule 3 of the rule is applicable for only such candidates who, in the ultimate result, fail in the departmental exam. And in case they appear in a departmental examination on another occasion, comma, they would not require to appear in such papers in which they have got exemption marks. There does not appear to be much clarity in the working of the rules. Under such circumstances, we have requested the learned, we have requested Mr. Nayak to inform us on the next date as to whether, as to the rationale of keeping such select list in the past alive for giving promotion, notwithstanding the existence of Rule 23 ever since the inception of the rules of 1995. And the reason for strictly enforcing the same in the case of the petitions. Whether in the case at hand, the petitioners would be required to sit in another departmental examination for their eligibility, regardless of the fact that they have obtained exemption marks in all the papers in the departmental examination held in the year 2019. So you have to tell us two things: the rationale and whether this is required. Mr. Nayak submits that necessary instructions shall be collected. Necessary instructions will be taken from the concerned department, and he shall get back to this court of the next stage. Re-notify 3 weeks. Lord.
16-6.
Mr. Chaudhary, that Mr. Nayak may be correct. No departmental examination, no compartmental examination, no supplementary examination. But for other examination, if you appear, you may not be asked to appear in those papers where you have received exemption in other papers. I think he can come up with this argument and that will be acceptable.
Let him put it, whatever he says, let him put it by way of an affidavit. That way, if necessary, we can.
Can say that, and that will be very logical. That way it does not affect the working of 20 sub clause 3. Then in that case, we will only ask him about the rationale of not enforcing 23 in the past.
Let him put it by way of an affidavit. That way, if necessary, we can respond.
To make oral submissions, no, when we are asking him to, he will definitely put it on affidavit, not on a plain piece of paper. He's not going to throw that paper to us, no. Don't frighten advocates for the state that put it on affidavit as if it's a threatening. You can't go beyond that.
I can't afford to do it because in another state I'll face the music.
Therefore, any statement that a lawyer makes, if it is based on facts, it has to be on affidavit. Do we accept plain papers? No, we don't.
16.6.
16.6.
Supplementary list item 35 and 36.
Mr. Puyer,
Yes.
You give us a 5-pager note.
Yeah. That
We
will be
fix it on
considered.
another date. Arguments will continue.
Yeah.
And then you're the amicus. No, you're for the
Amicus.
you're for the state. Where is Mr. Kamar?
Kamar was here, my lord.
No, sure. We have to go there. We'll fix another date today.
My lord.
As we told in the morning, we have to get up at 3:30.
My
Not
no issue.
concluded. Give us a 5-pager note.
My lord.
You know how?
Yes.
We want a fact sheet.
Yeah.
Correct.
Yeah. Each and every.
That is for the reason
Huh.
of the time constraint that we have
My lord,
for these 2 days. Otherwise, you can argue and no need of any notes of argument.
yes, but
Give
what
us a
I'm
fact
on
sheet.
with regard to the number of witnesses, my lord, what has come from evidence
Yes.
on record, why to be disbelieved,
Yeah.
and what are the grounds to be?
Correct.
That
Correct.
I will.
So we say that arguments to continue.
Yes, ma'am.
Arguments to continue. List this case. When do we list it? Monday.
I know.
Monday करते हैं? Monday complete करना. Monday we are not fixing any time limit.
Monday, my lord, I'll be, my lord, little bit constrained, my lord, out of station, my lord.
Mr. Kamar,
My lord.
date would suit you.
Sure, as your lord. Apna date. Monday could not.
No, I'm told you are the special public prosecutor
Yes,
in
my
another very important case.
No, right now the court is off, my lord, because she is preparing for the charge order.
It'll about the 13th, Tuesday. Over.
Wednesday?
Wednesday.
12.
Let's start around 12.
12.
No, ऐसा करिए.
12 is Tuesday here.
On 14th of
14.
14th of 46 cases. Analogous matter of how many cases? आधा घंटे का बस. नहीं होगा 15 को कर 15 को कर. Safe side में 19 चला.
Second up, no?
Safe side में 19. 19th of.
Yes.
19th of.
Deeply organized.
Much of it.